the likelihood that the state has also not presented a very, very convincing case in this regard. I don't say there is no case, but the case is not convincing. The court will accede to your release on bail, as I have already alluded to that aspect. Accused number 2 remains in custody and until the 13th of July of August 2025, unless the matter is expedited for the consideration of bail under Schedule C.
The National Prosecuting Authority, NPA, has withdrawn charges against crime intelligence boss Lieutenant General Khumalo, Brigadier Dinio Mokwil, Major General Nozifo Madando, and their co-accused. The decision followed a directive from National Director of Public Prosecutions Advocate Annie Motibi, who ordered that the case be withdrawn before any of the accused entered plea. The NPA said the matter could not proceed because investigations are still ongoing and the evidentiary record needed to prosecute the case is incomplete. Motibi further directed that the matter cannot be re-enrolled without his written approval. Should the Investigating Directorate Against Corruption, IDOC, later recommend prosecution, the affected officials will first be given an opportunity to respond. The withdrawal follows a disputed arrest process involving Khumalo that prompted complaints to the Ministers of Justice and Police. Although IDOC confirmed that an arrest warrant had been issued, the planned arrest never took place. Khumalo and Madando later demanded answers over why their warning statements were not taken and why they were instructed to report to Brooklyn Police Station in Pretoria with clothing prepared for possible detention. The officials also questioned the lack of communication surrounding the failed arrest attempt and called for proper notice should authorities decide to act in future. The latest development comes after the resignation of former IDOC head Andrea Johnson, who had been involved in the investigation into the matter.
Let me take the viewers backwards. On the 10th of July, when we were introducing where the people can find the IDOC judge, Advocate Motibi at the time announced that he is going to review all the matters that are dealt with by IDOC in relation to crime intelligence, and the review started at that point. Then along the way, the lawyers of the accused then sent representation to the NPA, directly to the NDPP, and they were also considered. Therefore, both processes were happening at the same time, and all of that led to this withdrawal of this matters, because in terms of the Section 1795, the NDPP used his powers, supervisory powers, to make sure that he can review this, which is something that happens all the time. And then he has found, among other things, that the investigations were not finalized. That's what IDOC has indicated to him, among other things, but also the issues that were raised by the lawyers of the accused people.
So was IDOC able to say, how did it take a matter that was not finalized to court? Have they said that?
Those are some of the things that we will deal with internally, because we needed to finalize these reviews and as quickly as possible because of the impact that it has on the matters that were already on the roll. Therefore, those are the issues. Today we went to meet with IDOC staff to just reassure them and make sure that those that are doing what is supposed to be done correctly will continue to do the work. But we also have to get to the bottom of really what happened, and that will be done in the days coming.
Let us read the letter from the NPA. Representations. Yourself regarding Khumalo and 7 others. Brooklyn case dated May 12, 2026, Risna attorneys, and your unreferenced representations dated May 11, 2026, Ndebele attorneys, have reference. 1. I acknowledge receipt of the above-mentioned communication, the content of which is noted. 2. The representations have been considered together with the memorandum submitted by the Investigating Directorate Against Corruption, IDOC. IDOC has advised that the investigation remains incomplete and that further investigative steps are required before a proper prosecutorial decision can be made. 3. In these circumstances, I have exercised the supervisory powers contemplated in Section 179(5)(c) of the Constitution and has directed that the charges be withdrawn before plea in terms of Section 6 of the Criminal Procedure Act 51 of 1977. 4. As the investigation has not yet been finalized and a complete evidential record is not presently available, it has been considered premature to determine the review requested in terms of Section 179(5)(d) of the Constitution at this stage. Independence, professionalism, accountability, credibility. 5. For the avoidance of doubt, the matter may not be re-enrolled, nor may any fresh decision to prosecute be taken without my express written approval. 6. Should IDAC, upon completion of the investigation, recommend that criminal proceedings be instituted, you will be afforded an opportunity to supplement your existing representations before the review is considered on the completed investigative record. Yours faithfully, Aktini Mutivi, National Director of Public Prosecutions.
This is a classic case. Bail conditions in our country are prescribed, but the powers for bail are given to the presiding officers. So when the presiding officer abuses the powers that they're given in order to benefit certain individuals, the only recourse that the person has is to go through the prescribed legal process that might take time. So while you're undergoing that process, the evil deeds that are planned, they continue. So I'll draw attention to a typical example that not me, but the judge have said it, which I made a reference to Ms. Korabana, what happened with the release of one of the police officers that was arrested. The magistrate released the man and says, go back to work. But another magistrate release other people on the same case. And the magistrate says, do not enter any premises of crime intelligence in the country. Now, I'm drawing comparison from the two professionals in the same court. Why would they come up with those conclusions? Call it an error. But they've been to court to try and argue this thing. The very same magistrate doesn't want to listen to them, and he keeps postponing until eventually he want to withdraw himself from the case. The magistrate, the court says the magistrate erred in coming up with a general. In coming up, allow me. The magistrate erred in coming up with a bail condition that the state did not ask for. So in that case, I'm using that as a typical example.
Yeah, but is that enough to infer?
No,
that these magistrates or judges who make mistakes, they make it all the time, every day. Everyone involved in the criminal justice system. That's why we have a system of appeals from the lower court to the highest court, so that mistakes and errors can be corrected. But my question is that sufficient for you to draw a conclusion or an inference that these magistrates, where one differs with the other, even in the same court, the same set of facts, that they are necessarily involved with crime syndicates or that they corrupt?
Honorable Chair and members, SC, I said the information in writing, information in recording of people talking is part of the investigation in criminal dockets that have been investigated. But the evidence that we're bringing to you is that typical example. Here is the team that is investigating drug squad in Gauteng. The team that get arrested on cases that you and me, you'll agree that at the first place, they should not even have been arrested. But they get arrested. As if that is not enough. This team is barred from entering crime intelligence offices in the country. Let it sink in, SC. It is a magistrate that exercises a bail condition that the state did not ask for. What does that do? It puts on hold the entire investigation in Gauteng. I told you, that these junior members are not sleeping at home. So they have to be paid for in accommodation, not a 5-star accommodation that has been alleged. But they must be paid accommodation where they must stay. They must get subsistence allowance where they are staying. They've got labor rights to work overtime and be paid. So they need resources. They're not getting this. Simply because the court decided that they must not participate in those things. I don't think if you get what I'm saying. Call it a mistake of the magistrate, but it's a deliberate to frustrate this part. And it becomes clear. So we don't need to say you have been part of this, but your action is assisting this. Oh, and I'm going to repeat again, see, maybe not getting me. We did not say Mr. Mkhunu is part of the syndicate. Remember we said that. We did not say that. We say he's an enabler for the criminality to thrive. We want to bring it to his attention. He does not want to listen. Instead, he's allowing this criminality to thrive by his action. So it's that what we are bringing to the attention of this parliament, that not to say that everyone that we've named have 100% contributed to this, but majority of them are the enabler of the wrong. So if people come to you for assistance and you help them, you are participating. Yes, the end result of a person to move drugs from point A to point B is to make money with drugs. But you're a police officer of the law, you hold a roadblock on the road. If a person says, make sure there's no roadblock and he gives you money, it doesn't tell you what the reason why you must not have a roadblock is, because it's going to be moving something. It just simply say, make sure there's no roadblock. Or if there's a roadblock, tell me. It ends there with you. And you do that. You share that information, there's a roadblock at that point. That's enough. This person knows I must not go that route, I must take another route. You are participating indirectly. So these presiding officers, we cannot say they are making honest errors, because we've seen that I'm not a lawyer myself. I'm a police officer. So some things just don't make sense when the courts or the presiding officers are exercising their judicial powers on decisions that they take. Yes, I know the recourse of that is to launch investigations. But while we're launching investigations, things fall apart. And what we're on the verge of doing in this country was to hand over the country to the people that were going to control it. Honorable Chair and members, had the National Commission been removed for whatever reason, SBIA would have become the acting National Commission. That one I can tell you. Members of IDEC that were investigating told me that.